for purpose, so contractors would be well advised to ensure such purpose is clearly defined in the contract. Next slide, please. Subclause 4.3 includes requirements relating to the contractor's representative. This is a key role in the contract, and the representative should either be named in the contract or at least confirmed prior to commencement. It should be noted that the commencement date is typically 42 days from the letter of acceptance, but this is often shortened and there's usually not much time to find and get approval for a contractor's representative. The contractor's representative is required to speak the language of the contract, and the employer must not unreasonably withhold approval of the contractor's representative, as the works can't proceed without such approval. Next slide, please. Subclauses 410 to 412 are three of the most important clauses in the contract, and claims and disputes often arise in relation to these clauses. Subclause 410 covers the provision of site data by the employer, which must be given to the contractor at least 28 days before the date for submission of the tender. The obligation for the employer to provide site data to the contractor is an ongoing one, and the employer is to provide any such data that comes into his possession even after the base date. To the extent which was practicable, the contractor shall be deemed to have obtained all necessary information which could affect the works, which includes the form and nature of the site, including subsurface conditions, and the contractor's requirements for access, accommodation, facilities, personnel, power, transport, water, and other services. Next slide, please. Subclause 411 states that the contractor shall be deemed to have satisfied himself as to the correctness and sufficiency of the accepted contract amount, and makes reference to the site data referred to in clause 410. It's worth remembering that the contingencies listed in subclause 410 are not exhaustive, and the contractor will be deemed to have based his tender on all information which he could get to the extent that was practicable, taking account of cost and time. Next slide, please. Subclause 412 covers unforeseeable physical conditions and confirms that a contractor is to submit a notice if he encounters such conditions. Such notice is to describe the conditions and the reasons why the contractor considers them unforeseeable, and the contractor is to give the engineer the opportunity to inspect the conditions. Physical conditions can include natural and man-made phenomena, but they must be not reasonably foreseeable by an experienced contractor by the date of submission of tender. By way of example, I've seen contractors trying to claim additional money for unexpected rock excavation based on photographs of the alleged rock submitted long after the excavation was completed. Under such circumstances, claims are unlikely to succeed. Following the submission of such notice and details of the impact of the unforeseeable physical conditions, the engineer is required to make a determination under subclause 3.5. It's worth noting that the engineer can consider if the works in other parts of the site were more favourable than expected, in which case he can reduce the net impact of the conditions accordingly. Next slide, please. And finally, on clause 4, subclause 4.21 covers progress report requirements. This clause itself stipulates the details to be included in the monthly reports, but many employers have their own additional requirements, and it's important to remember to check the particular conditions of contract to ensure full compliance. Progress reports are listed as one of the documents to be submitted along with interim progress payment applications, so they're an important document. This clause has been criticised for the amount of detail required. However, as someone who spends most of his time working as an expert witness in construction disputes, I'm often disappointed at the lack of detail or accuracy in monthly progress reports. I would strongly recommend that contractors put as much accurate detail and records into their progress reports as possible. So that completes my review of what I see as the most important subclauses of clause 3 and 4. I hope this has helped to raise awareness of the importance of these two clauses, and I'd just like to end by reiterating that these clauses are often amended, usually by the adding of additional requirements. While it may seem obvious, I'd just like to remind any contractors listening in that you must always consider both the general and particular conditions of contract when preparing your tenders. Thank you for listening, and back to you, Raj.
Yeah, the way that we plan to do this is after each speaker, the panel will discuss some of the points, interesting points that came up in the course of the presentation. So I will, can we get the video up of the, we have Rodney and we have Rammit. If you all can unmute yourselves. Now, obviously, the first thing that Garth talked about was the ability of, or the lack of ability there of the engineer to amend the contract. Now, this is interesting because there was a recent case in the High Court where the High Court disagreed on a different form of contract of the power of the architect to bind the employer. And this would seem to make it clear in the contract. Any thoughts from either of you?
Rammit, do you want to go first?
Okay. I think the concerns is, I mean, I do agree, you know, I mean, with that, I mean, that perhaps there could be dangers when decision of the architect binds the employer. I think that would be a concern. So I think some you know, considerations have been placed on the powers of the employer's representative at the end of the day. So I think he has been.
From my part, I mean, it's clear in the FIDIC contracts that the engineer has two roles. One is as the representative of the employer, and the other is the certifier. And I think one criticism of the 1999 forms is that the position of the engineer isn't entirely clear, especially when it comes to the determinations, which isn't on the point that you've raised, Raj, but I just wanted to say that. And also, if I could, just to let the participants know that we decided when we prepared for this to use the 1999 forms. Of course, the 2017 forms have come out and they're starting to be used around the world. But in our experience, it was seen that we all shared the view that 1999 forms of the FIDIC contracts are still very much being used in Malaysia. And there aren't too many signs of the 17 forms coming in, the 2017 forms. In terms of the determinations which are made, this is a problem that I found with engineers who don't have the independence that they should. In the 2017 forms, the independence that's been required of the engineer is expressly stated. So in the 1999 forms, although determinations to be made, it's not always in practice the case that engineers are independent in doing so, because they're often employees of the employer. But coming back to the point you made, Raj, about this, the duties and the fact that under FIDIC, of course, it says expressly in 3.1, the engineer shall have no authority to amend the contract. I think that's a very practical item because, of course, the engineer isn't a contracting party. Only the employer and the contractor have the power to amend by agreement the contract.
Yeah, the point would usually come up in the context of the failure to give notification, because sometimes, or very often, in fact, when an application is made for extension of time, for instance, or loss and expense, the engineer would proceed to evaluate it on the merits. And then there comes up the argument as to whether or not the engineer was acting as the agent of the principle, and thereby varying the terms of the contract to dispense with the need for adequate notification. So that's the background context in which this kind of clause might be useful to the employer to show that it can't be done unless there's an express variation. Now, I think let's move on to the next one, because we're getting into some very interesting areas with the contractor. Now, on the issue of 410 about where the contractor is responsible for the adequacy and stability of the works. Now, this is a very interesting situation, because what happens if, in this particular case, like if we are talking about the Red Book and where it's to build to employer's design, if the design was defective in the first place, in the sense that you could never have reached a level of stability, where does that place the risk on the contractor? Maybe Garth, you might want to have a thought on that.
Sorry, right. That's in relation to clause 4.1, was it?
Sorry, Garth, did you have any thoughts on that?
Yeah, sorry, could you repeat the question?
Yes, the question was, the contractor is responsible for the stability of the works while the works are being constructed. But if it is being done to an employer's design, and the employer's design, even when the works are completed, are not capable of reaching a level of stability, is the contractor still responsible for the stability of the works?
My view under clause 4.1 is yes, he would be. By submitting a tender, he's basically saying he can build what has been designed. So yes, I believe under those circumstances, he would still be. The risk is all with the contractor.
If I could just add something there, it depends, I suppose, when it became apparent to him that the works could not be upheld, or the stability, or there was an issue with the design. And if under FIDIC he's not the principal designer, surely that would be the obligation of a contractor, the duty to warn as a contractor and not a designer. But of course, clause 4 anticipates that the contractor may be doing some design work as well under the contract where that's provided for. So I guess it depends is the answer, right?
Yeah, it depends on the particular. Rammit, anything to say on that?
Yeah, I mean, I agree. If the contractor is not taken the design liability, then there is a duty to warn. I think as such, I do agree with what he said.
Yeah. Okay, that's another area of very interesting law, but I don't think we want to get into that. I think the point that seems to be common among all of you is the very classic Duncan Wallace view, which is, sorry, the contractor, once you've accepted the responsibility, you have to build no matter what, unless it becomes impossible and the contract is frustrated. But okay, that's your thought on that. And then now the other one was on the site data, provision of site data. To what extent is the employer responsible if the site data is insufficient, or if there is something lurking that wasn't picked up by the employer, but then is the contractor is going to hit that problem? Okay. Who would like to go first?
I think there's an obligation on the employer to continue to provide data beyond the base state that's in as it becomes available to him if he hasn't already got it. Of course, if he already had it, he was obliged to give it to the contractor. But anything new that comes along, he's obliged to continue to give that to the contractor. So the odds aren't all against the contractor. There is an obligation on the employer to keep providing information. As to the adequacy, again, it depends on the circumstances. And the contractor has a problem with deciding at tender stage whether there is enough information. If there isn't, whether he has enough time in tender to go out and provide and obtain enough information to put a proper tender in. And very often the contractor will merely rely on the insufficient data available, and that will lead to disputes post-contract.
Okay, I think we are running short of time. Is there anything of burning importance in what Garth said that any of you might want to just bring up in about 30 seconds? Nothing? Okay, let's move on to you now, Rod. And I should give your intro. Rod's another old friend of mine. We've worked together in cases, and he's been here for many years. He's the chief executive of the Charlton Martin Group, and he's worked for clients in Europe, Africa, the Middle East, and India. He's got dual qualifications in quantity surveying and law. He's a chartered quantity surveyor, and he is someone who is a fellow of the Chartered Institute of Arbitrators in both and also both the Malaysian and Singapore Institute of Arbitrators. He does expert witness work and has been appointed as arbitrator, mediator, adjudicator, dispute resolution, dispute adjudication board member in Malaysia, pretty much covering the entire spectrum of dispute resolution mechanisms in this country. So, Rod, would you like to start your presentation?
Thank you very much, Raj, for that introduction, and hello, everybody, and welcome. I'm going to try and get my slides to work, and I'm going to deal with the very important clause 8, which deals with time, essentially, under the contract, commencement, delays, and suspension. And first of all, clause 8.1. Again, I'm just going to go through what I think are the most important provisions because we don't have time. 8.1, the commencement of the work, as Garth has mentioned, either it's stated in the contract, in the letter of acceptance, or it's not. If it's not, then the engineer gives the contractor 7 days notice, and the commencement date must be within 6 weeks of the letter of acceptance. The contractor is to commence work as soon as practicable after commencement date. That all depends on whether he's in country, whether he's coming from overseas, and all of the rest of it. Contractors proceed with due expedition and without delay. Those are familiar words in other standard forms of contract. And we have other words which are used regularly and diligently. And of course, that's a very important obligation for contractors, because if they fail to meet that standard, then that is one of the reasons that they can be terminated very often in construction contracts. FIDIC uses due expedition and without delay. There's an overriding obligation, obviously, to complete the works within the time for completion, capitalized because it's a defined term. And FIDIC, as you probably already know or have realized, prefers to use days rather than dates. So there'll be a prescribed number of days after the commencement date by which time for completion has to have occurred. And as usual, the contractor's obligation is to complete within that period of time. And the number of days is stated in the appendix. What happens if the employer doesn't give notice to commence? Well, that's a breach of contract. Arguably, it could be a fundamental breach, which may entitle the contractor to get out of the contract, but not many contractors really want to get out of contracts. They're there to do business and to hopefully make a profit. So it would only be probably in those rare cases where a contractor is coming into a developing country and is quite exposed. And if he doesn't get that instruction to proceed, then he could arguably, depending on the law, terminate the contract. Again, Garth mentioned reference to program. There is a requirement to provide a program, as there is with so many other standard forms of contract, early on, within 28 days, so that the engineer can review it and decide whether it's a reasonable plan for the work to be executed and for monitoring the progress of the work. Then we come on to 8.4, which deals with, of course, situations where the contractor needs an extension of time, needs more time because of certain events. It's the EOT provisions, 8.4. And the beginning of the clause says this: the contractor shall be entitled, subject to subclause 20.1, which Rammit will deal with, contractor's claims, to an extension of time for completion, if and to the extent that completion for the purpose of subclause 10.1, taking over the works and sections, is or will be delayed by any of the following clauses. Then there's a list of clauses, which I'll briefly deal with in a moment. But what can we see from these particular words? Well, the contractor shall be entitled to means that it's not subject to the opinion of anybody. In some contracts, it's up to the opinion of the architect or the engineer or the SO as to whether more time should be given. FIDIC doesn't do that. It says the contractor shall be entitled, subject to giving a notice under 21, and subject to there being a delay which will affect the taking over of the works and sections as per 10.1. So it's meaning it has to be a critical delay because of one of these reasons. Then an entitlement to extension of time is there. The clause ends after the list by saying, if the contractor considers himself to be entitled to the EOT, the contractor shall give notice in accordance with subclause 20.1. When determining each extension of time under 20.1, the engineer shall review previous determinations and may increase but shall not decrease the total extension of time. So there, it's very important for the engineer, and they seldom are, but it's important that the engineer is not over generous with giving an extension of time, because he can't reduce it subsequently. He can take into account events going forward and give perhaps a lesser extension of time for future events, taking into account a review of earlier delay events, but he can't take back additional time once given. So what do we see from this clause? Well, notice of delay is a condition precedent to the right to an extension of time. If you tuned in yesterday, you would have heard Stephen Shee complaining about the ridiculous provision for notices when there are obvious delay events like the floods or like the MCOs and so on that we've had. But there are good reasons, as in that same panel, Louise mentioned, that's what the contract says. And FIDIC, as with so many contracts, requires notices to be given. And if the contractor doesn't give a notice of delay, then he loses the right to an extension of time. So it's very important that the contractor realizes that this is what he must do and isn't shy to give notices. As Raj mentioned, I've been here many years. When I first came to Malaysia, I was a little shocked by contractors who were embarrassed and unwilling to give notices as the contract requires because they didn't want to upset the consultants or the employer. Well, of course, it is the employer's contract. He's the one who drafts it. So we shouldn't be worried about upsetting the employer if we're merely following what the contract says. Now, onto those events just briefly. The problem, I would say, well, not problem, but the difficulty for some interpreting the contract is, unlike many EOT clauses, we don't have a straightforward list of items in clause 8.4 here. We have to look elsewhere in the contract. So there are provisions such as listed there, 1.9, 2.1, 4.7, 4.12, various subclauses which have the entitlement to EOT stated there. So elsewhere in the conditions, we have to find the list of provisions, but there are many guides available and guidebooks which conveniently list out those items. The sort of things are typical. And for example, 1.9 deals with delayed drawings or instructions, 2.1, rights of access to the site, 4.7, setting out, 4.12, unforeseen physical conditions that we just mentioned, fossils, antiquities, etc., interference with testing, changes in legislation, contractors' entitlement to suspend, and so on, are all quite normal events giving rise to a claim for additional time on behalf of the contractor. Exceptionally adverse climatic conditions is really what we know in our standard forms, domestic forms, as adverse weather conditions. And there is no definition of what those would be. So reference to data, the engineer would have to look at the conditions which would be prevalent at the site in the location and whether there were adverse climatic conditions which the contractor suffered. Unforeseeable shortage of personnel or goods due to epidemic or government action, that's very topical with the MCOs and COVID. Delay, impediment, or prevention of employers' personnel or employers' contractors on site. Unforeseeable delay caused by authorities and consequences of the engineer's instruction to suspend. So a long list of items, and the FIDIC contracts are considered to be fair contracts, well drafted, and the risk allocation balanced. We've probably got more items of EOT for the contractor here than in many other contracts. And of course, as with other contracts, the clause preserves the contractor's obligation to complete within a specified time. Extending completion date preserves the employer's right to delay damages. So we have a mechanism of time under the contract. It's a currency just like money, and that needs to be extended if the employer or an event for which the employer takes the risk under the contract occurs. So we need to be able to regulate time and extend the completion date to allow delay damages to be imposed thereafter if the contractor fails to complete by that extended date. Two conditions precedents. One is one of the listed events has resulted in an actual delay. Now, Stephen mentioned yesterday flooding, obviously, but it's not so obvious. Obviously, there was a flood, but was it in the vicinity of the site? How did it impact the contractor's ability to do the work? MCO, everything stops, it's obvious, agreed. But normally it's the event and it has resulted in an actual delay to the progress of the work, which will delay the completion of the work. The second condition precedent, as I mentioned, is timely notices has to be given as per clause 20. No notice, no EOT entitlement. The fair determinations under 3.5, I mentioned that earlier. That's a bugbear for me because actually when you look at FIDIC, there's an obligation of the parties to try and agree, and only if they can't agree on, for example, an extension of time, then the engineer should come in and carry out a determination. But there should be a discussion between the parties facilitated by the engineer as per 3.5, as per clause 3, to try and agree on the amount of EOTs as with agreement on any other types of claim under the contract. And that seldom happens in my experience. Clause 8.6, rate of progress, where delay is contractor's responsibility, the engineer can request a revised program showing acceleration measures. Any cost incurred by the employer as a result of revised program is claimable in addition to delay damages. So first of all, if the contractor is in delay, the engineer can say, look, I want you to avoid that. You're in breach because you're late. What can you do to overcome it? And if the contractor comes up with a proposal to work overtime, then that's what he's required to do. He will incur costs, but of course, if the delay is reduced, he won't incur delay damages. Delay damages are the term used in FIDIC for liquidated damages as we know them domestically here in Malaysia. Employer cost, he may incur additional costs through his engineers or his site supervision in supervising the works during the overtime working periods which have been proposed by the contractor. That's separate from costs arising from a delay itself. So that's a separate claim to delay damages, and reasonably so. And just to move on to delay damages, as with the usual in standard forms of contracts, the amount is stated in the tender documents, and also there's provision to cap the amount, which commercially for contractors tendering, particularly on international contracts, is quite common to have a capped amount of delay damages. The employer must make an application for a claim by the employer against the contractor in accordance with 2.5. So there's a procedure there for the employer to follow. He can't simply deduct the amount from a certified sum. And again, as usual, where there are sectional completion requirements, then the delay damages must be provided for clearly in the contract. Where a subsequent DOT has been granted, then there's provision to refund delay damages which have already been imposed. Okay, that's the important points on clause 8 that I wanted to deal with. Back to you, Raj.
Thanks, Rod, for that survey of this very important clause. Now, some of the things that came up that might merit some discussion is when we talked, you started off by talking about the commencement and the failure to commence being a ground for possible termination by the contractor. Now, do you have any thoughts on when that notice to commence must be given in relation to the award of the contract?
It's pretty clear that it's within 42 days. So the commencement date to be within 42 days. So the notice has to be given 7 days prior to the actual date. So it would be within that period. So it's within 6 weeks. And the idea is that if a letter of acceptance is given, then the contractor should be mobilizing, getting ready to start, and therefore a commencement instruction should come thereafter. Very often, and usually these things are stated, the date is stated in the letter of acceptance. But if it's not, then that falls in under 8.1.
Rammit, anything to add to that?
Yeah, I mean, I agree that typically the date will be listed. Otherwise, there are provision in FIDIC with the number, with the dates. Yeah.
Garth? Sorry, muted, Garth. Sorry.
I was on. Yeah, no, I'd just say, with it being such an important aspect of the contract, the commencement date, I would always prefer to be absolutely certain about it and to stipulate it in the letter of acceptance, I think, would always be preferable. Yeah, that's all.
And then Rod mentioned the extension of time shall be given, so it's mandatory. It takes away any discretion on the part of the engineer. Any thoughts on that, Garth?
I mean, the engineer shall give an extension of time, but he very often won't, or is reluctant, at least until the employer buys into whatever extension of time he's thinking of granting. I know the word shall doesn't give him an option really not to, but he's still got to be convinced that there is a valid extension of time to be granted.
Yeah.
Which I think is the main hurdle.
Yeah. It is interesting because I noticed in the audience we have Nasim, who's always talked about whether shall means may and things like that. So I'm sure he'll put in a question in the chat box.
Just on that point, Raj, if I can just pick up on something that Garth mentioned. Of course, the engineer must take into account the employer's views and as well as the contractor's claim, but he's got to get on with it. He should get on with it, and he should move, and he has to make a determination to allow the project to run. And so often we see that engineers are not doing that for a variety of reasons, which causes disputes and uncertainty. Of course, the contractor has a lot to do in providing enough detail in the first place for the engineer to do that determination.
And then the other thing that I think, as you mentioned, is very topical is this unforeseen shortages of material and goods caused inter alia by epidemics. And so obviously the last couple of years, that's been a huge concern. Now, one of the things that this might become very useful is because our COVID Act is only confined to measures taken under the Prevention and Control of Diseases within Malaysia. But, you know, if you have material, for instance, or finishers or lifts or things like that, which are supplied from overseas that are affected in those countries, then you would really need to have a provision like this. Do you think it would be far enough to extend to COVID-related issues or epidemic-related issues outside the country? Garth, any thoughts?
I would think it has to, really. I mean, I know I've heard complaints from many contractors about not being able to get equipment, materials from overseas. It's obviously been a real problem for everybody over the last couple of years. My feeling is they should be entitled to some sort of compensation for that. Whether it's only in respect of time or whether they're entitled to time and costs, obviously will be dictated by the terms of the particular contract. My personal feelings is it's very tough for them to have to deal with that sort of situation without any compensation.
Actually, you brought up a very important point, Garth, which I think is probably the more important point than what we started off by talking about. The issue of whether or not there should be compensation beyond time in terms of money. Now, let me just throw something out here, because yes, everyone feels sorry for the contractor, but let's not forget the employer also is probably potentially facing losses. He may have to deliver to somebody else, a developer, for instance, so would it be fair to compensate the contractor with money as well as time? Rod, any thoughts?
Well, I think FIDIC is quite generous in that respect. And I didn't mention, I apologize, on my slide 8.4, where I listed out the provisions, I gave asterisks where the contractor can claim time and cost, and also time and cost and profit under FIDIC. So there are provisions. For example, changing legislation would allow cost as well. But it all depends on the circumstances. There's a duty to mitigate as well. But of course, under the circumstances where everybody is suffering, and the conversation that Contractors is having is, we understand what the contract says, but where's that going to take us to? Where's that going to lead to in our industry? There must be a sharing of the burden coming outside of the contract and being realistic and sharing the pain. So yes, everybody's suffering, the employer will suffer. In terms of cash flow and immediate direct costs, it's down to the contractor and the subcontractors. So if employers can appreciate that and think of the longer term consequences on their projects, if they just shut the door and say, I'm sorry, Mr. Contractor, it's your problem, that's not going to solve provide a solution. So I think there needs to be a lot of recognition that cost, and this is really where FIDIC comes in. It does allow for cost where other contracts don't.
Okay, I think we have to push on because I think we are running very short of time. We'll have to move to Rammit now. Now, many of you might have remembered Rammit when she was the legal director in the AIAC. And since then, she's gone off to run, or she's a founding partner of a boutique consultancy firm providing ADR services and legal support. And then that's a very interesting angle, I would say, from the usual path that most lawyers take. Now, Rammit, when she was the head of legal services, was involved in quite a few landmark initiatives by the then KLRCA, the Islamic rules, for instance, which won a GAR award, and also the drafting of revisions to the arbitration rules in 2013, fast track rules, mediation rules, and the arbitration rules. And she also, as everyone else on the panel, sits as arbitrator and adjudicator. She's a fellow, and her recent claim to fame was she's one of the co-authors of the textbook Mediation Practice and Procedure book, which made a bit of a splash a little while ago. So with that, Rammit, would you like to start?
Thanks, Raj, for the kind introduction. So before KLRCA, more popularly known as, someone who was with KLRCA, but I was with Prasarana, before that KTM. So in Prasarana, I've had, quite a chance with FIDIC, but that time it was FIDIC Yellow Book, because for the purchase of trains and all of that. So so much of my experience prior to AIAC was in drafting of contracts and etc. As an in-house counsel. Now I'm just going to proceed further. I'll be dealing with, let me just share the slides. Okay, I'll be dealing with clause 20 of FIDIC on claims, which deals with claims, disputes, and arbitration. Right. Clause 20, you can say that it is more of a procedural clause under FIDIC. And I will proceed with clause 20.1, the contractor's claim. So clause 20.1 deals with a contractor's claim, setting out procedure for the notification and substantiation of claims and the mechanism of decision making of the process by the engineer of the claims. So if a contractor feels or believes that there is a claim arising, either claim in terms of time or additional payment, in reference to the clauses under FIDIC, which Garth and Rod has actually mentioned earlier, and there were cross-references to clause 20.1. So clause 20.1 provides the avenue. And if there is any claims arising where the contractor is aware or has become aware of, or should have become aware of this claim, in terms of, that additional time will be required, or the contractor will be incurring additional payment, the contractor must give notice as soon as practicable or within 28 days. Now, this notice requirement, has a very grave effect, because if the contract, it has the effect of being a condition precedent to the claim. And we are talking about calendar days when we refer to FIDIC. Now, if the contractor fails to notify claim, then the contractor, within 28 days, then the contractor actually loses the right to claim. And so that's why it's quite a grave clause, and contractor must be aware of this if they are especially using FIDIC contract 99 version. And FIDIC clearly, the clause clearly states that if notice is not given within the timeline, the employer will be discharged of all liabilities. And this is stated clearly. And there are case laws which supports this time bar. It does have a time bar effect. There's a lot of case laws which discuss about it, but it is accepted as a condition precedent to claim. Now, recent cases, for example, the case of Gibraltar, I won't go further into the case because due to limitation of time, does suggest that the clause itself should not be strictly, read against the contractor. However, the contractor must give the 28 days notice, but the notice itself does not have to take a particular format. So long as the contractor puts a notice in writing, because FIDIC does not say that it has to take a particular form, it has to be in writing. It describes the circumstances or event by which the impact of time and or additional payment, there is impact, and the notice itself, it can be recognizable as a claim, and that is enough for the contractor to put in within 28 days. Now, then the contractor can provide fully particularized claim within 42 days and support its claim the particulars with contemporary records. Now, contemporary records simply means records which are original, and these are primary documents that is produced or prepared at the time of giving rise of the claim. It is not documents that is prepared at the point of, substantiating, etc. It has to be at the point when it has to be contemporary in nature. Now, the contractor is required to provide this particularized claim within 42 days. And then the engineer is required to respond, at least in principle, whether it approves or disapproves within another 42 days from there. Now, if the claim has a long-term impact due to any instruction or any variation, and if it is a continuing impact, then the contractor can provide the claim particularization, etc., or notice on interim basis, and these interim monthly claims will be submitted until the claim event ends, and the final claim, when the claim event ends, within 28 days, the final claim can be submitted by the contractor. Now, the clause further provides that the obligation of the engineer then is to certify for payment claim amounts that the contractor has reasonably substantiated as due under the provision of the contract. Now, just as a summary, the onus and the burden of proving the claim itself and substantiating the claim is actually on the contractor. Now, but if the contractor is using the defense that the contractor did not provide notice in time, example, the 28 days notice, or if the contractor is late, then the burden is on the employer to prove or to show that the contractor is actually late in giving the notice. So that's sort of just giving a summary of the case law positions. I'm just going to proceed. So that clause 20.1 deals with contractor's claim. Now, what happens if there is a dispute in terms of the determination of the engineer, or there is a dispute between in regards to the claimant's claim? Then FIDIC contract provides for a dispute adjudication mechanism within the contract itself. So there's dispute adjudication board, which will deal with these disputes in regards to the claims. Now, parties are required to jointly appoint a dispute adjudication board, and the dispute adjudication board may be appointed, the parties can appoint a standing dispute adjudication board, as in that they are appointed and they maintain the board throughout the contract, or there can also be an instance of an ad hoc appointment of dispute adjudication board once the dispute arises. Now, essentially, the dispute adjudication board under FIDIC, the requirement is it's either 1 or 3 persons, but if the parties did not agree to any particular number, it will be 3 persons. The dispute adjudication board members, either 1 or 3, will incorporate general conditions of dispute adjudication agreement, which is in the appendices of the conditions itself. So this agreement is signed by the member and the parties to the contract. Now, the conditions of dispute adjudication agreement basically deals with the details and the obligations of the DAB member. It provides the obligations of employer and contractor. And in terms of obligation, it deals with the duty to be impartial, independent, in regards to appointment, in regards to payment, and terms of references, etc., and the procedure that will be adopted by the DAB, and also powers given to the dispute adjudication board, etc. So it sets out the procedure, it sets out the term of reference. Now, parties are to agree, or the conditions of dispute adjudication agreement has the terms of payment. It could take in the form of monthly retainer or daily fee, and reasonable expenses are to be shared between the contractor and the employer. But if the contractor fails to make this payment, etc., the agreement as it is does provide that the employer then has to make the payment and ensure that the DAB, the DAB setup is there under the contract to ensure that the work and etc. and the contract itself can progress, right? Now, clause 20.3 goes on to deal with if the parties fail to agree with the DAB members. So failure to agree, this is in terms of appointment itself. If parties fail to agree, there are instances stated there, then the appointment will be made by the appointing entity. This one parties can agree to in the appendix to tender who is the appointing entity that will appoint in case parties are unable to agree to the DAB members. Now, if the appointing entity end up making that appointment, then it will be final and conclusive. Again, it's parties, both parties to the contract are responsible to share the remuneration of the appointing entity. Now, clause 20.4 is the one that provides for references that is to be made to DAB. So when there is any dispute arising from claims under the contract, then parties shall refer to the dispute adjudication board. And the reference of this dispute will be made in accordance with the provision 20.4. And upon receiving the references, the DAB has to make a decision within 84 days or such other period that is agreed by both parties. Now, if DAB actually fails to decide within time, then parties may actually give notice of dissatisfaction within 28 days after the expiry of the initial 84 days. Now, notice of dissatisfaction, if parties do not want to be bound by the DAB decision, that they must give notice of dissatisfaction. Because if otherwise, if DAB makes a decision within time, etc., and parties do not give any notice of dissatisfaction, the decision will be binding and final. Now, the decision of the DAB is binding on parties and they are supposed to promptly give effect to the decision unless the parties have moved on and agreed to settle, that there is an amicable settlement, or if the matter had proceeded to an arbitration award, which I will deal with shortly. So parties dissatisfied with the DAB's decision may give a notice of dissatisfaction. But what is the effect of this notice of dissatisfaction? It does not take away the binding nature of the decision. Parties are still, even if parties place in or put in the notice of dissatisfaction, the decision is still binding. Parties must, the contractor still has to go on doing the work, and the employer is bound to make payment in accordance with whatever decisions that DAB has made. However, if the notice is not given, like I mentioned earlier, the decision becomes final and binding on both parties. So this is something which is important to note. Now, just to give a broad overview of the intention and purpose of the DAB, the Dispute Adjudication Board, within the mechanism of FIDIC contract, this is to ensure that the contract can go on, because payment and performance cannot be withheld when parties are in dispute if you know the project is to go on or the contract is to go on. So the DAB, essentially, the setup of the DAB itself ensures the continued performance of contractor's obligation and the employer's obligation to make payment in terms of the DAB's decision. And if parties are dissatisfied with the decision, there is a final avenue. The avenue is through amicable settlement and arbitration. Now, clause 20.5 provides for the avenue for amicable settlement. So parties can attempt to settle, and parties has to wait for 56 days from the date of the notice of dissatisfaction prior to commencing arbitration. Now, the amicable settlement itself does not have an effect of being a condition precedent to commencing arbitration, but the 56 days waiting period is the timeline that parties must wait before commencing arbitration, right? Now, clause 26 of FIDIC basically provide for the reference to arbitration. So where a notice of dissatisfaction of DAB decision has been served, and where any dispute in respect of that decision which has yet to become final and binding, it can be finally settled by international arbitration. Now, parties can agree to the set of rules, etc., but in absence of agreement, ICC rules of arbitration will apply. Again, in absence of agreement, the panel of 3 arbitrator, and the language will be based on the language of the contract itself, language for communications in the contract. And parties are not limited in the arbitration proceedings to the evidence that they had previously put before DAB. So parties can actually put further documents or change their references, etc. They're not bound by the evidence or the documentations that they have placed before the DAB. But the DAB's decision is admissible in evidence. The engineer can be called upon as witness. Now, the arbitrator is given the powers to open up, review, revise any certificate, determination, instruction of the engineer, or any decision of the DAB which is relevant to the dispute. Now, so what happens if there is a failure to comply with the DAB decision? So if DAB decision becomes final and binding because no one actually placed in or submit the notice of dissatisfaction, and in the event one party fails to comply, then the other party may refer this failure of compliance to arbitration as well. So there's again an avenue. And clause 20.8 provides what happens if there's an expiry to DAB's appointment, or there's a failure in setting up the DAB itself, or when DAB is not in place, then again parties can proceed to arbitration, just to ensure that there is no gap in reference to arbitration. Now with that, yeah, I'm done in dealing with clause 20. Thanks. It's a bit quick.
Thanks, Rammit, for that. Now, in relation to what you just said, it was quite interesting because there was an actual situation we had, and now that it's in the public domain, I can talk about it. In the smart tunnel dispute, which involved the tunneling contractor, Waste and Freitag, and I believe it was Gamuda. What happened was there was a dispute adjudication board convened, and the DAB came up with a decision. And what happened was the Gamuda didn't want to comply with the decision, and there was an application to court for summary judgment. And the court refused because they said you have to go to arbitration. So it appears as if a failure to comply with a DAB decision requires you to go to arbitration. So my question is, if that's the case, it seems to be a bit, at least within our Malaysian context, it seems to be a waste of time to go through the DAB process if you haven't convened a standing DAB from the start of the project to avoid disputes as they arose. Any thoughts on that?
Well, it depends on, if the DAB reaches a decision that the parties are happy with, then there's the point of the DAB. But I think not everybody would not be willing to abide by a DAB decision, Raj. That's my view.
Yeah.
Of course, I was on the losing side, so it doesn't.
No, but I was a bit disillusioned with the DAB process because it seemed to have no teeth. If you could get hit with a stay application because there was an arbitration provision, you left thinking, then why did I go to the trouble of going through the DAB process? Having said that, I think the DAB itself, if it was implemented in the way the FIDIC had intended to basically to be a means to avoid disputes arising in the first place, which means you have a standing DAB convened right at the beginning, and they meet periodically, and they attend to disputes which parties may not want to abide by the engineer's evaluation because they may not feel he's objective. But if they were to have somebody, an independent tribunal, which they had participated in appointing, they're more likely to actually accept it in the court, while the project is proceeding, and get on with life, and then at the end of the day, it won't blow up into a full-blown dispute. Any thoughts?
I've been on a DAB where all the DAB decisions were accepted and there were no disputes going to arbitration, and that was successful. The problem with DABs, or the perception, is that they're expensive. And I know major infrastructure projects in Malaysia who, for one phase, had a DAB standing, and then in the next phase, they decided not to have a standing DAB because they saw themselves spending all that money and not getting anything for it. But of course, the counter argument is, because they're there are no disputes, so they contribute to avoiding disputes, which is your point, right?
Yeah. Garth, any thoughts?
Yeah, I would just say my experience, while one party or the other has not always accepted the DAB decision, they do very often lead to settlement discussions and ultimately agreements. But it's rare that the actual findings of the DAB are paid out in full.
No, but it's strange because there were two instances where I personally was involved with, where the DAB decision was not adhered to and parties had to proceed to arbitration. And they were fairly major projects, So I think it really depends on the parties' appetite for further proceedings.
Yeah.
I think I want to give some time to address some of the questions that came from the floor. Now, I'm going to have to be a bit arbitrary here. Well, one interesting question was one from Nasim, which talked about the contractor's design liability in clause 4.1, because he correctly points out that the engineer's obligation is, if the employer employs an engineer to do the design, his standard of care is the ordinary professional standard. But if the contractor adopts the design, or the contractor is responsible for design, then it becomes a fitness for purpose obligation. There seems to be a gap there in the liabilities, So, and it gets even worse if the contractor employs an engineer to do the design, and the engineer can wash his hands and say, "Look, I exercised all reasonable skill and care," but the contractor is still liable to the employer for fitness for purpose obligation. So the question is, how do we address this?
Well, it's a difficult problem, and this is when I joke and say, well, that's why I'm not a design and build contractor, and I'm sure Naseem would say the same, because it is the risk that the contractor takes on, and it's difficult. How can he pass down that obligation when his engineer that he employs wouldn't give him anything other than reasonable skill and care? But it is the absolute legal obligation, isn't it? It's akin to manufacturing an item in a factory. The design and build contractor is giving a promise that it will be fit for its purpose. Interestingly, in the 2017 forms, the need for what the purposes are, I believe, has to be defined. So it's been addressed somewhat in the new FIDIC forms. But that doesn't get away from the fact that the contractor is taking on this higher obligation, which nobody can help him with. And the other point that Naseem made in his question was, what about insurance? He can't get insurance, PI insurance for it either. But let us know how to address it, Raj, because I can't think of a way.
Yeah, Naseem has just popped up on his chat, from the chat, and let's see what he says.
Oh, okay. So the JCT is to reduce it down and give a reasonable skill and care undertaking, but going away from one of the benefits of getting a design and build contractor because of that higher responsibility.
Now, there was another question which related to another interesting point, which is where there is a mechanism for extension of time, and the parties have seem to have overridden it by their agreement. Would that extension of time mechanism still survive? Any thoughts?
Can I go first because it was my area, but I'll be quiet after that because I've spoken a lot. It depends on the wording of that agreement to extend, but if there's an agreement between the parties to change the completion date and everything else is left intact, then of course then the mechanism under the EOT provisions of 8.4 would remain, I would say.
Yeah. And kind of an associated maybe question with time is that Kenny Lee says, project delayed, contractor submitted EOT application pursuant to clause 20. Engineer is either not making any determination or under-evaluated the EOT. And the question is, what's the recourse of the contractor?
There's a dispute, right? There's a dispute that has to be resolved. So go off to DAB and get a decision from the DAB.
If a decision is made, which is what the contractor doesn't agree with, then I would agree with you. But what if no decision is made?
Then it's a breach by the employer because his engineer hasn't acted.
But does it set time at large?
Possibly.
Yeah. Funnily enough, we were just researching this point, and there is a case where that seems to suggest, it was a fairly old case, but Supreme Court though, Tamesa Design, and it adopted a passage from Professor Vincent Powell Smith's book, The Malaysian Standard Form of Contract, where it actually does say that if he fails to, where there is no provision under the EOT clause for that particular contingency, or if there is a provision and he does not exercise it, it sets time at large. So that's an interesting insight from that case. Any other thoughts that from the panel?
One problem contractor may often have is, very often the DAB clauses are removed under the particular conditions. They're taken out of the contract, which leaves them basically with arbitration, which means he's got to wait until the very end. So it leaves him in a very awkward position of really not having any idea if or when he might get an EOT.
But I think we have to also look at the spectrum of contracts, because you have, the average contract in this country is not that high value to start with. But then you have the big infrastructure contracts, which are of very high value. And that's exactly what I think the DAB was designed for, dispute avoidance in large contracts. It was extremely successful in the Channel Tunnel project, for instance, where they really reduced the number of disputes. And I believe in the Hong Kong airport project as well, DABs were very successful. And it's a bit of a shame that they are not, that sometimes maybe through a lack of understanding or perhaps being penny wise pound foolish by saving the cost of a DAB upfront, but having to put up with a hugely expensive arbitration at the end is something that maybe education may be the answer to this.
Or as an alternative, Raj, the dispute advisor, the late Colin Wall, who you would recall was based in Hong Kong, and he was very successful on complex hospital projects as being an independent single dispute advisor appointed by the parties to sort out the problems as the project went on. And that's a similar facility to avoid disputes and avoid the arbitration costs.
I'm trying, there's one of the questioners who said he's asked a lot of questions, but we've not addressed him. Let me try and see whether there's anything that we can.
If Cindy can send the questions and the person's contact details, I'll be happy to send him an email and answer some questions if there isn't enough time in this forum.
Yes, I think, because
likewise.
we've come to the end of our time. It's Biplab Som. Perhaps if you can share with the organizers your email, Rod or any one of us will respond to your questions because we've run out of time, but we would like to answer your questions. And I've had to be a bit arbitrary in choosing the ones that I thought would generate most discussion. But anyway, we've come to the end, I believe, of our session. And I want to thank the panelists. It's been a very lively discussion. And it always helps when we can see that everybody's in rapt attention, even though we've overshot our time by 17 minutes now. So I will now pass it back to Heather